2311 Racing and Front Row Motorsports filed an antitrust lawsuit against NASCAR a few weeks back. Since then, a lot of events have unfolded. In the judge's latest ruling, the court denied the plaintiffs a motion that would have made a huge difference in the team's operations. As it stands, 2311 Racing and FRM have not signed the new charter agreement that would have guaranteed them charters for the 2025 season. If they don't have charters, the teams will have to run as open teams next year. This could affect the team's revenues drastically. Hence, both teams need to convince the court to allow NASCAR to let the teams compete as charters during the duration of the lawsuit. To convince the courts, the plaintiffs needed a few private documents from NASCAR that could show that running as open teams would not be profitable for 2311 Racing and FRM. To prove this, the teams requested documents from NASCAR to support their arguments, but this has been denied by the judge. Here's what the judge said in the legal documents. While the proposed discovery request may help plaintiffs show a likelihood of success on the merits, they are not sufficiently narrowly tailored, and plaintiffs argue the record is sufficient to support their motion for preliminary injunction as it stands. Plaintiffs seemingly misinterpret this factor. As to this factor, plaintiffs argue that they can show a likelihood of irreparable harm, presumably in support of their motion for a preliminary injunction, without access to expedited discovery, but seek expedited discovery to create a more fulsome record. In doing so, plaintiffs concede that they do not actually require expedited discovery, at least for the purposes of their motion for a preliminary injunction. The court notes that while the requested expedited discovery could potentially help 2311 Racing and FRM argue that they're likely to succeed in their case, the requests are too broad and not specifically focused on what's essential at this early stage. Courts prefer narrowly tailored discovery requests, especially for expedited requests, to avoid unnecessary burdens. The plaintiffs argue they'll suffer irreparable harm if they're not given charters for the 2025 season without a preliminary injunction. This harm must be likely and unavoidable if the injunction isn't granted. They also seek expedited discovery to strengthen this claim of harm. Yet they argue that they already have enough evidence to meet this standard. By saying that the current evidence is already enough for their motion, the plaintiffs essentially admit that expedited discovery isn't absolutely necessary for their preliminary injunction request. This undercuts their argument for needing a faster discovery process because it suggests they don't actually need more evidence to make their case at this stage. Hence, the court has denied the plaintiffs' request for submission of certain documents. So now there is a chance that the teams will not be able to compete in the 2024 Cup Series as charters. But how will this affect the team? Racing without a charter in NASCAR is a difficult position for any team, but it poses specific challenges for 2311 Racing and Front Row Motorsports, two teams currently in a high-stakes legal battle with NASCAR. Both teams filed an antitrust lawsuit against NASCAR over the charter system, arguing that the system restricts fair competition and stifles team growth. Initially, 2311 Racing and FRM sought a preliminary injunction that would have allowed them to participate as chartered teams in the 2025 season, while the legal proceedings continued. However, as the lawsuit progresses, there's a strong possibility that they may have to race as open teams instead, facing significant operational and financial hurdles as a result. For 2311 Racing and FRM, not having a charter in 2025 would mean entering each race as open teams. NASCAR's 40-car field reserves 36 spots for charter teams, guaranteeing their participation. Open teams, however, must qualify on speed to secure one of the 4 remaining spots, introducing weekly uncertainty. If 2311 Racing and FRM are forced to race as open teams, they could face increased pressure to consistently qualify on speed, adding an element of risk that charter teams do not face. This unpredictability could disrupt their race strategies and weaken their season-long performance in the NASCAR Cup Series. The charter system is designed to provide chartered teams with a steady income from NASCAR's revenue-sharing model, which includes TV rights and sponsorship deals. For teams like 2311 Racing and FRM, charter status ensures a baseline income each season, which is crucial for budgeting and planning. If they are forced to race as open teams, they would lose this financial stability, relying solely on race earnings, which vary based on their finishing positions. Without the guarantee of consistent revenue, they would be in a tougher spot to sustain operations at a competitive level. The sponsorship appeal would also be affected. Charters provide teams with stable participation in each race, a major selling point for sponsors seeking reliable exposure. As open teams, 2311 Racing and FRM might find it harder to secure long-term sponsorships, as sponsors may hesitate to invest in teams with uncertain race participation. This could reduce their funding and make it more difficult to compete on equal terms with chartered teams. As chartered teams, both 23XI Racing and FRM benefit from perks such as preferred pit selection, which gives them a strategic advantage during races. Without a charter, they would be lower in NASCAR's pecking order for these benefits, which could hinder their ability to maintain a competitive edge. In a sport where small advantages can have significant impacts on race outcomes, the loss of these perks could make it harder for 23XI and FRM to stay competitive with the top teams, especially during crucial race moments. Operating without a charter introduces an element of financial unpredictability. For 23XI Racing and FRM, running as open teams would mean bearing higher costs with less certainty, as they would need to prepare for each race on a week-to-week basis. The absence of a guaranteed spot in each race would complicate logistical and budget planning, stretching their financial resources as they compete against chartered teams who can plan and allocate resources for the entire season. Additionally, if they face last-minute changes to qualify for each race, these costs could escalate, intensifying financial strain. While racing without a charter is possible, it's challenging and demands consistent performance, strategic budgeting, and robust sponsorship. For 23XI Racing and FRM, the potential shift to non-charter status would require adjustments across operations, resources, and financial management. Both teams would need to find ways to overcome the uncertainty and financial limitations associated with non-charter participation as they fight for a place in NASCAR's competitive hierarchy. If 23XI Racing and FRM are required to race as open teams in the 2025 NASCAR season, they'll face significant disadvantages compared to chartered teams. The absence of guaranteed starting spots, limited revenue potential, sponsorship challenges, fewer resources, and unpredictable costs could make it difficult for these teams to compete consistently. This development underscores the importance of their antitrust lawsuit, as both teams fight for a system they believe could foster a more equitable playing field for NASCAR competitors. NASCAR's response to the antitrust lawsuit filed by 23XI Racing and Front Row Motorsports appears to be a strategic move to pressure both teams into dropping the suit. NASCAR has signaled that if 23XI and FRM continue their legal battle, they may lose their current status as chartered teams, forcing them to compete as open teams in the 2025 season. However, there's a possible offer on the table. If both teams agree to abandon the lawsuit and sign the new charter agreement, NASCAR will allow them to retain their charters and avoid the logistical and financial setbacks of racing without one. This maneuver reveals NASCAR's intention to control the discourse surrounding the charter system, as well as to limit any potential restructuring that could arise from the lawsuit. By using the charter system as leverage, NASCAR is creating a high-stakes dilemma for 23XI Racing and FRM. The charter system guarantees spots in each race, financial stability through revenue sharing, and access to crucial resources, all vital for team survival and competitiveness. Without a charter, both teams would be forced to race as open teams, which means qualifying on speed each week with no guarantee of making the starting lineup. In a system where only 4 spots are open for non-chartered teams, this would inject a level of uncertainty and financial instability that most NASCAR teams can't sustain over the long term. This situation has effectively placed 23XI and FRM in a bind. Dropping the lawsuit and signing the new charter agreement would allow them to return as chartered teams, securing their place in the NASCAR Cup Series grid for the 2025 season and beyond. But maintaining the lawsuit in pursuit of a potentially more favorable and transparent system means risking their current operational stability. NASCAR's approach also puts financial pressure on the teams, as charter status is closely tied to revenue and sponsorship. Charters offer a guaranteed income through NASCAR's revenue-sharing model, making it easier to attract sponsors who want reliable exposure. By threatening to strip these teams of their charters, NASCAR jeopardizes 23XI Racing and FRM's ability to secure sponsorships, potentially eroding their financial foundation. This tactic could force the teams to rethink the lawsuit as they weigh the risk of alienating sponsors or losing revenue without the guaranteed starting spots that charters provide. This situation highlights NASCAR's determination to maintain control over its charter system. 23XI Racing and FRM's lawsuit challenges the exclusivity and limitations imposed by the current charter structure, arguing that it restricts fair competition. If successful, their case could lead to a significant restructuring of how NASCAR grants and manages charters, which could open doors for other teams to enter the sport more freely and reduce the charter's market-driven exclusivity. By making charter retention contingent on dropping the lawsuit, NASCAR sends a message about its unwillingness to allow teams to challenge its authority and the existing revenue model. This approach forces the teams into a lose-lose scenario, either abandon the lawsuit and comply with NASCAR's terms, or risk the financial and competitive disadvantages of operating as open teams in a system that inherently favors chartered teams. The situation between NASCAR and these teams has implications beyond just 23XI Racing and FRM. How NASCAR handles this case will likely set a precedent for future conflicts, as other teams may question the equity and transparency of the charter system. A decision to drop the lawsuit and sign the new agreement could signal that teams are under pressure to comply with NASCAR's structure or risk being sidelined. What do you think 2311 Racing and FRM should do if they're not allowed to compete as charters in 2025? Post your thoughts in the comment section below.